Hello there, my name is Vasily Tarasenko, I'm a Russian attorney. If you delivered the goods to Russia without a signed contract and the buyer received the goods but didn't pay for it, a reasonable question arises. Can you collect debt without a supply contract? The answer is yes, but there are some nuances which I'd like to discuss today. Legally, the role of the contract is to consolidate and, if necessary, prove the arrangements reached between the parties regarding their obligations to supply the goods. With regard to the supply contract, the key terms that must be agreed between the parties are the name and quantity of the goods to be supplied. In order to sue without a written supply contract as one document, you will need to collect evidence of two case circumstances. First of it, it's the supplier and the buyer have agreed on the essential terms of the contract, and second one, the fact that the supplier delivered the merchandise and the buyer received it. So evidence that the court will require when collecting debts without a supply contracts are consignment note, payment invoice, order card, goods supply application, email correspondence even, and other evidences of argument. In order to prove that the goods delivery terms were agreed upon without a contract, it is necessary that the main facts could be determined from the documents listed above. The main are the name of goods and quantity of goods. So, how to win in arbitration dispute if supply contracts were not signed? If the above information is contained in the documents you provided, the court is more likely to grant you the claim. The court will determine important facts for the case, such as: has the supplier issued an invoice for paying for the goods? For example, if an invoice was drawn up and sent by the supplier to the buyer, the court will qualify this action as an actual offer. Did the buyer pay against the invoice? If the buyer paid against the invoice, for example, paid an advance payment for the delivered goods, the court unconditionally qualifies this as an acceptance. Have the goods been delivered by the supplier and accepted by the buyer? These all are important questions. The court, having established that the supplier delivered the goods agreed in various documents and the buyer didn't pay for the received goods, will have to recover the cost of the delivered goods from the buyer. I hope this information was useful to you. My name is Vasily Tarasenko, I'm a Russian attorney, and good luck.